Welcome at this HR quarterly update during this, and bear with us with this heat wave. My name is Nikki de Groot. I'm an employment lawyer at Pallas Employment Lawyers, and I'm here with my colleague Julien Blok.
Yes, good afternoon.
Some practical notes before we start is that afterwards you will receive the slides of this presentation. If you have any questions, you can submit that in the chat, and at the end of the presentation we will answer your questions. And for now, I will guide you to all the topics we will cover this quarterly update. We will start with some update on legislation. Afterwards, Julien will talk about AI and the Works Council. After that one, I will cover the dismissal due to performance and disturbed employment relationship. After that one, we both will cover some recent case law. And of course, during our presentation, we will share some practical tips, some great best practices focused on HR professionals. And what I said before, if you have any questions, you can submit this in the chat, and we will answer at the end of the presentation.
Yeah, if we cannot answer them today, we will get back to you, of course, because then we have your info as well.
Okay, then the floor is yours.
So first we wanted to start indeed with some update about the employment legislation. As you may have heard or read, the Dutch House of Representatives adopted a new act on the 12th of May. It's the Security for Flexible Workers Act, which includes some changes to Dutch employment law. But first of all, I need to address that these changes are not final yet. This act needs to be discussed still at the Dutch Senate. And the first debate is at this moment scheduled for next month. And then the expected implementation is the 1st of January of 2028. But some important general changes following this new Flexible Workers Act is that for agency workers in Phase A, Phase A is only possible for 52 weeks. That was initially 78 weeks, but this is already included in the collective labor agreement for agency workers, that it is only possible for 52 weeks. So despite the fact that this act is not applicable yet, it is already included in the CLA. Another change is that for Phase B, only 6 contracts in 2 years will become possible. That was originally 4 years, is now included in the CLA for 3 years, included in the CLA, or in the collective labor agreement. The other possible or expected change for agency workers is that equivalent employment conditions to employees in a comparable position at the client is applicable. This is already also included in the collective labor agreement, but will become a law if this and more included in Dutch law if this act is becomes final. And I think that the biggest possible change is with respect to the chain of contracts, because this new Flexible Workers Act includes that the current interruption period within the chain of contracts of 6 months will become 36 months. The initial proposal was 5 years, but due to some amendments following the discussion in the House of Representatives in May of this year, they amended it to 36 months. It's good to understand that a little bit of history. Before 2015, Dutch employment law included that it was possible to have 3 contracts within 3 years with an interruption period of 3 months. In 2020, in 2015, that became 3 contracts within 2 years with an interruption period of 6 months, which means that after those 6 months, that chain begins to run again. And then in 2020, it was amended to 3 contracts within 3 years with an interruption period of 6 months. And now it is expected to become 3 contracts within 3 years with an interruption period of 36 months. So if this act becomes legislation, then that I can imagine is a big change. And this is not, of course, only applicable to agency workers, but also for all employees with fixed-term contracts. Another change in this act is for on-call and min-max contracts, which become bandwidth contracts, which includes that a contract has a minimum and a maximum with a difference between a minimum and a maximum of a maximum of 30%. So if you have a 10-hour contract, then the maximum can only be 13 hours. There are some exceptions for young people with part-time jobs and state pension recipients, to which it will not be applicable. And the last change is the option to include in the contract that no wages are due if there is no work. That will be no longer possible, only with the exception for pupils and students during the first 6 months of the contract. So I think that these changes, especially the chain of contract, may have a big impact. I also understand that following the news from today that the Bureau of Statistics in the Netherlands reported today that during the first 3 quarters of 2026, more flexible workers than in 2025 are working in the Netherlands, and that includes on-call workers and fixed-term employment contracts without the possibility to or the perspective to get an indefinite term contract. On the other side, there are less contractors and less. With this new possible legislation, I think that the government and the legislator is trying to have more security for those flexible workers because of this increase of also flexible workers in the Netherlands, and they want to push employees more and more into less flexible contracts. As I already mentioned, the expected implementation of these new changes is the 1st of January of 2028, but it's not certain. It's still possible to amend following the Dutch Senate debate, and so we will keep an eye on that. Nikki.
Thank you. The other topic we want to touch upon is about the secondment and posting of workers. And let me tell you something about the scope, because nowadays there is a lot of abuse in the market, they say, and we want this more transparent and a more level playing field. We have the scope is you have on one hand the suppliers and on the other hand the hires, the company who hire people. And what we cover is every secondment can be affected, and also every posting is affected, and that's for foreign companies and for Dutch companies who are posting or second people in the Netherlands to another company. So there is a new act, the Act on the Admission for the Posting of Workers, and this will change substantially the Act on the Allocation of Workers by the Intermediaries, the WADI. So the WTTA, that's the acronym for the new Act, will have some changes, and it affects actually a new system. Now we have a kind of for posting a registration requirement, and we go to a licensing and new admission system. And what does that involve? you need to be registered with the trade register of the Dutch Chamber of Commerce. You need a certificate of good conduct, and you also need to have a deposit of 100k, just that you can make sure that you can pay your wages, your administrative fines, taxes, and social contributions. So the official admission will take place, and there will be also a register. There will be also a new authority, and that's called the Dutch Labor Leasing Authority, in Dutch de Nederlandse Autoriteit Uitleenmarkt. And they will monitor this this new system and the admission system, but also the ones who making use of that's for the suppliers to get in to get the admission. But at the same hand, there will be a system that when you hire somebody via an intermediary, that you can check, okay, this company certified has gone to an admission system, and that's safe. There are also some consequences, because if there's no admission, then there's no lawful supply of labor. And I will focus this time more on the hiring companies. Maybe that's you are a company hiring people through an intermediary, and you also have some obligations. And that's one, the verification duty. So you need to check before you engage people that somebody has a valid admission. And if you have unlawful labor, there are also sanctions, and that could also be an administrative fine. There are some transitional provision, because there will be a new system that will will start 1st of January, that you can apply for your admission, and then in 1st of July you can check, okay, is somebody registered or not, and then it will start, and the enforcement will start in 1st of January 28. Why is it important now? You think maybe it's far away. Maybe you're working right now with some suppliers, and you want to secure some continuity, and there will be a lot of changing coming up. So it will also, please make sure that you review the contracts before 27, and also update the agreements with, are there any warranties for compliance with the WTTA? Are there any obligations to notify immediately? And what are your termination rights? If somebody loses admission, or if somebody didn't apply for the admission, then you not want to terminate probably the contract. Otherwise you risk a fine. That was my short update. And
thank you.
I'll give it to you.
All right. Because many of you already know, our firm assists a lot of employers, but also a lot of works councils. Therefore, also a lot of works council members join us today, hopefully during this heat wave. But if we take a look at the topic, which is relevant for both HR and works councils, I think that AI and the implementation of AI tools and the difficulties around this topic are very relevant for employers, but also for works councils, especially because we receive a lot of questions around this topic, and there are many discussions between companies and works councils about the legal framework applicable to this topic, and because this is still a very difficult aspect and new to everyone. Also, with respect to case law, this is very new, and it becomes more relevant and relevant every day. And we wanted to touch upon this topic today. So what are the legal options for a works council, and therefore what do you need to take into account as an employer if you have a works council and intend to implement or change a system or regulation including AI? So the legal options following the Works Council Act for the Works Council are the right of information, the right of initiative, right of advice, the right of consent. There's also the European AI Act. And I also wanted to discuss with you today how to work together on these topics, because I think that that's eventually the most important part. A little bit of history. I like history, but I think that a lot of you still know, maybe from the past, already these things, the highs and the Golden Line, etc., etc. So all of these things were around the time that the Works Council Act was lastly updated with respect to the especially the right of consent for the Works Council on matters which are now relevant with respect to AI. So you can ask the question, is the Works Council Act still relevant or appropriate at this moment in time? I think the answer is yes. I think that the Works Council Act includes sufficient possibilities for a Works Council with respect to AI and all of the changes applicable at this time, but possibly more case law is also necessary to get a better understanding of how to use the Works Council Act. Then about the legal options for the Works Council. The right of information includes that the company needs to provide the Works Council with all information and data that the Works Council needs to perform its duties in a good way. That is also in connection with Article 24 of the Works Council Act, and is therefore, in my opinion, already immediately an important part of what I wanted to discuss with you today. Because if the company has the intention to implement a new tool, including AI, which is a lot of times now the situation, or a new tool has the support from AI, this falls within the scope of Article 25 of the Works Council Act, the right of advice, and Article 27, the right of consent for the Works Council, then the company needs to inform the Works Council timely about this intention to implement such a tool, or that it is busy to see if it wants to implement and can implement such a tool. So, because if there is a plausible chance that the right of advice or the right of consent is applicable, then the company already needs to inform the Works Council, and that is something that is forgotten a lot of times. Of course, the Works Council has also the right of initiative, so the Works Council can submit proposals to the company, for example, regarding guidelines on transparency, privacy, oversight of human control with respect to such AI tools, but also the principles of a response, how we use in a responsible way AI. And the Works Council can, of course, also always, if there is a consultation meeting with the company, put these subjects on the agenda of such meetings. Then another legal option for the Works Council is the right of advice. So in the event of a significant organizational or technological change, such as the introduction of an AI system, and of course that depends on your company and what impact that has, then the Works Council has the right of advice, and you need to ask the Works Council for its advice before you can implement such a tool. So it's applicable to for example, the introduction of a new technology for production processes, a reorganization resulting from AI, optimization or outsourcing of tasks due to AI services, or also, and that is also a topic which is a lot of times forgotten or not in scope of the company and the Works Council, is that when the company engages an external expert regarding AI, then the assignment to the external expert is also falls within the right of advice for the Works Council. So the right of advice for the Works Council concerns the use and the necessity on one hand, for which problem do we want to solve with AI, why do we need it, and also on the other hand, what consequences are there for the employees and implementing an AI tool. Will there be redundancies or is additional training necessary? And how are these consequences mitigated? Training or other measures. And the last part is that the Works Council also has the right of advice if the introduction of an AI system includes a major investment. And then it needs to be not an investment on which a lot of companies have on a day-to-day business, but it needs to be a major investment and to fall within that scope. Another legal option for the Works Council is the right of consent, which is a more far-reaching option, you could say, is that the Works Council needs to ask for its consent to implement it, and without the Works Council's consent, you cannot implement the intended new regulation or tool. For example, about regulations about working hours, working conditions, following the implementation of an AI tool, staff training. But what we see most of the times is that it is about the privacy of the employees and or monitoring performance or attendance of behavior for employees, which can be followed more easily with the use of AI. That most of the times is also then connected with the privacy of employees. So that it's not only about monitoring, it's also about privacy, and how AI uses that personal data. Examples are indeed to monitor employees for optimization for appraisals and recruitment, or algorithms that lead to tasks redistribution or less tasks that need to be performed by employees by human work. We also have the European AI Act, which becomes applicable on the 2nd of August of this year. And that includes that high-risk AI systems, if that becomes applicable, that the employer shall inform the employees and representatives, so in the Netherlands the Works Council, and the affected workers that will be subject to the use of the high-risk AI system. The first question is, of course, what is a high-risk AI system? I think that the most applicable one is the employment and personnel management. This follows from the Data Protection Authority in the Netherlands. They have a list of what they consider high-risk AI systems, and then personnel management, and then AI system that automatically selects CVs or for recruitment, etc., etc. If those are developed or implemented, then you need to inform the Works Council. However, we already have that in place following the Works Council Act. So the European AI Act with respect to this part is, I think, less relevant following the Dutch Works Council Act and everything that we have already in play. So how to work together on these topics? Be aware that more changes to regulations include the implementation of AI and are connected to privacy regulations. Following my own work with Works Councils, still people are still finding out that indeed more and more is connected with each other. As employers, I would say start timely and transparent conversations with the Works Council to discuss these intended changes and what these intended changes include with respect to AI, privacy, data gathering, etc., and why it's necessary and how it can be used. Also, because a lot of people still have are hesitant again about these changes, and if a timely and transparent conversation it might be could help to that. Yeah, and how it will help and assist the company with the strategy and the mission, and so that more changes fall within the domain of the Works Council. And other topics are, for example, agree with each other about if an AI system is implemented, about evaluation of the AI system or regulations, and involvement for the Works Council, about the Works Council's involvement if such a system is updated and maybe additional algorithms are in play in order to the AI regulation or system can do more following an update. Do you need to agree with each other how you want to process that in the future? As mentioned, the company has the possibility, of course, to engage an expert, but the Works Council also has that possibility to engage experts, especially because this is a very difficult topic, has legal aspects, but also a lot of aspects about the technology and what is possible with those systems, and what systems and what does it include for the employees in the company. Then, Nikki.
Thank you. Lately we also cover a lot of reorganizations and restructures in our practice, but we still get also a lot of questions about performance and the disturbed employment relationship. And when can you dismiss? What is due process? How can I document well? So what I want to do in this next few minutes, I want to shortly discuss the legal framework, the basics. Then I will also inform you a little bit about some case law development, some recent case law in which we also see some tips and best practices for your daily practice. How, as an HR professional, can you tackle this issue sometimes, and how can you implement a due process, and also make sure that if you need to dismiss someone, that everything is checked and you'll be successful in case of a dismissal case. So the law gives us a framework. We have a closed dismissal system, and if you want to terminate, you will request that from the sub-district court for a regular employee. And we have this framework of that you need a reasonable ground for dismissal, and you also need to make sure that redeployment is not possible. If is somebody ill, then there is their prohibition for termination. What I discussed, what are reasonable grounds? That could be a performance-related dismissal or disturbed employment relationship, and sometimes there could also be culpable conduct in this kind of situations. There are more reasonable grounds, but I will not discuss this today. For the dismissal due to poor performance, and when is there such a ground? And it's actually really, we can read it in the law, and it should demonstrate that there's unsuitable, that the employee is unsuitable for performing the agreed duties. So then we're just looking at the recent job description, for example, but over time his job will evolve, and we look at the actual needs and skills of his job today. Then it's also important that if there is poor performance and there are some shortcomings, that they are timely informed. What I will touch upon also later is that you give them a chance to improve. So that should be also some time frame and also a real opportunity to improve. And that somebody shows some poor performance should not be related by an illness or disability. And also important that it should also not be the result of the inadequate training that should be provided by the employer. Today, it's very, very difficult to dismiss based on poor performance. We see only a success rate of 15 or 20%. That's only the cases that that are published in the published court cases. So the phases before we don't see, but if an employer decided, okay, I want initiate a poor performance case, only 50 or 20% will succeed. What is the most reasons of a rejection? An insufficient improvement process. We call that also the performance improvement plan. It's not that's not stipulated in the law how it look like, but we can give you some guidelines based on case law, based on our daily practice. First and foremost, and what's important to start with, is the documentation. And also the framework of the law is also important, and we look at the agreed work. Are you able to perform the agreed work? The required skill set, your qualifications. And what I said also before, the job requirements may evolve by an organizational change or AI. So we're looking at the factual job but also make sure that you're not targeting a more senior level or another job. This is your framework you work with. We talk about agreed work. If there are any shortcomings, then the performance concern should be communicated. In our daily practice, we say, okay, you have to understand as an employee that there are shortcomings, but it's never written. So we ask you, okay, please include it in emails, include it in evaluation meetings, and make reports of that. And it should also make sure that if there are any performance issues, that it's not related to certain stress or complaints created and linked to any illness. So we come to the performance improvement plan, and we have some tips for that. So what I said before, documentation in writing is very important. If you come up with concrete feedback, make it very concrete, and use examples and also factual observations, because you need to know in what way you need to improve, and you need to know, okay, this is the yardstick of my job description. I have to improve this and this. Then it should be clear, and the improvement objectives should be stated very smart. And you should focus on the quality of work, and you could also focus on the behavior or the quantitative results. But as soon as you can make it very concrete and use examples, then you can count on this is understandable for the employee. But later on, if this comes to a court case, you also have to show this to the judge. During your performance improvement plan, you, as an employer, you also have to offer meaningful support, and that could mean internal coaching, external coaching. It could be that somebody is mentoring. You can provide some training, and sometimes it's if it's something with behavior, maybe you can provide mediation. All that kind of tools you can offer, but also make also a clear description in the performance improvement plan that this is also covered and part of the performance improvement plan. So to make sure that as employer, you're offering the best support. How long should a performance improvement plan take? We say there's a rule of thumb 3 to 6 months. If it's somebody very senior and it's more complex, it could be up to 12 months, a year. And sometimes we see that you start with a plan of 3 months, and if you conclude, okay, maybe we are not there yet, but we want to invest again, then you can extend it with another 3 months. But you should be very clear upfront how long it would take and what are the consequences. And during that process, it's also important that you have interim evaluation meetings. So to discuss the progress, and also please document this, because at some point, if you're improving, see a lot of improvements, great, but still there are some improvements not satisfied, then you can still point that out. Okay, we're not there yet, and that this is XYZ. Sometimes it feels a little bit negative. You need to improve, and we have to see a lot of effort from you, but also important to maintain a positive and constructive approach. Because the goal is not to dismiss. No, the goal is actually that the employee shows some improvement and that he or she remains successful in the current role. In the plan, it's also important that you are transparent about the possible outcomes. So if improvement is achieved, the process will be continued, you keep your role, and you continue in your current role. If the improvement is not sufficient, then you have to consider what are the options, but also make clear what are possible options. Do you have to look at a redeployment, demotion, or potentially dismissal? But please make sure that you're clear about that upfront. What we also see in our daily practice is that we see a two-track approach. If you opt for such approach, then we say, okay, do that very carefully, because otherwise you risk that later on maybe you push too hard for a settlement agreement and you didn't give the opportunity to a performance improvement plan and not a real chance to improve, then probably you will risk that you will not get rejected just because of this attempt. But there is also, if you approach it carefully, then there could be a two-track approach, but then you should be very clear from the beginning. There are two options, generally two options, and a credible option. And you can say, okay, we have this performance improvement plan. It's very well documented. These are the improvement plan. It will take 3 or 6 months. These are the possible outcomes. Or instead, you can also sign up for a settlement agreement. And this covers, of course, a certain package. You need to be very clear on the communication. And also to make sure that this is really a voluntary choice for the employee, and both options are fine. This is not a choice of the employer. We want you to sign the settlement agreement. There should be real two options on the table, and then you can, and if you do this diligently and carefully, you can take this two-track approach. Maybe nice to also shortly touch upon some case law, because we can learn from the mistakes from others, maybe how we could structure the process best. And my first case is from the Court of Appeal of Amsterdam. It's quite recent, from 31st of March this year. And this employee joined IBM since 1st of April 22 in a sales position. He received bonuses in 22, 23 and 24, but he was rated expect more for business results in 22 and 23. But he only achieved 75 of his targets. So there you see already a little bit of a mismatch. In 24, this employee was placed on a PIP. He failed to complete it successfully. Then the PIP was extended until the end of 24, and this was also successful. End of the year, he was offered a settlement agreement, which he declined to sign. And in January 25, he also achieved only 46% of his annual target. And we know that the PIP he didn't complete successfully. IBM initiated termination proceedings based on poor performance, and the district court granted the dismissal request effective 1st of August 25 and awarded the employee a transition payment. That's the minimum, and additionally held that the IBM acted seriously culpable in handling the improvement process, awarding him 10K fair compensation. And that was because there were some misunderstandings about, hey, why can you have bonuses? And also the improvement points were not clear. It was not structured well. It was not clear what, there were no meetings, no interim meetings. So that was not the due procedure we want to see in the improvement plan. The employee appealed, and the Court of Appeal held that the IBM failed to prove poor performance, merely because merely missing sales targets does not automatically constitute poor performance. And IBM did not clearly identify the employee's shortcomings or community-specific areas requiring improvement. And the PIP from IBM was too generic, and there were insufficient evidence, and the employee had been properly informed that his job performance was considered inadequate, or that dismissal could result from a failure to improve. So, what IBM also failed to do is meeting the redeployment obligation. So it said, okay, you didn't investigate at all whether he could redeploy it in your international group before seeking dismissal, because as we said before, that is next to a reasonable ground. You also have to tick the box of redeployment obligations. And instead of reinstating the employee, the court concluded that the employment relationship would likely have ended within a short period of approximately 6 months. How they come to this conclusion was not clear from the case law, but okay, we consider that. And even though IBM didn't reach a threshold of seriously culpable conduct, that is the threshold for a fair compensation, they say, okay, but that you didn't tick the box of the redeployment efforts, they increased the fair compensation from 10K to 50K. Okay, I have also another case from the Court of Appeal, 19 May, also Amsterdam. I forgot to mention that, but 19 May, quite recent. This employee was employed as a location manager at the DC Kliniken for quite some time. And there was earlier already a performance improvement plan, but this person succeeded. And there and also in 2022, they were very positive about the location manager. In 23, this person experienced some health problems. She didn't disclose it with the employer, but she was criticized on her performance. And then she got some mixed feedback on her performance review. And then she got also a warning that she's failing to comply with agreed commitments in end of 23. Eventually, the employee called in sick, and she remained incapacitated. And here you see that probably the performance was also linked to her illness. And what they also did, what the court didn't like to see was she wants to reintegrate. There was a lot of discussion because she wants to reintegrate in her own position, and this employer doesn't want her to reintegrate in her own position, but seeks reintegration outside of the organization. And also, because of this discussion, they had a mediation about this, and that was not successful. And then they initiated termination based on poor performance. The sub-district court rejected this. It was linked She was still sick, so there was still the prohibition. Then there was an appeal. Then she was by that time fully recovered. Again, the court said poor performance had not been proven. She didn't complete a performance improvement plan. She received generally positive evaluations. There was no clear improvement targets. And that was all before her sickness absence. The court also rejected dismissal based on disturbed employment relationship because there was not a real concern, and she would just want to return to her own position, and the court said that is also a right that she has. And then the employer was actually also contributing to this employment conflict, and the employer perception of the damaged relationship alone was insufficient to justify dismissal. And the court ruled that the redeployment requirement was not satisfied and therefore upheld the sub-district court decision refusing termination of the employment contract. So there was a whole process of poor performance, disrupted relationship, and she's still employed. What we see also in practice that sometimes poor performance shifts to a disturbed employment relationship. And I just will touch on briefly what constitutes a reasonable ground if we have a disturbed employment relationship. Then the employment relationship has to become seriously and sustainably disrupted. Repair of the working relationship can no longer reasonably be expected, and the disruption is so severe that the continuation of the employment is no longer feasible. And as an employer, you have to demonstrate that the disruption is both seriously and lasting. And if the employee disputes the existence of disrupt relationship, it's also important that you provide evidence. If the employer has significantly damaged or disrupted the relationship, then it has also to show there is some de-escalation measures. And otherwise, you risk that there's a rejection of the dismissal, or you risk there's even a fair compensation on top of the statutory transition payment. Here, I also have some case law to illustrate disrupted employment relationship. This is from the court in Gelderland, 15 May 26. And the employee is employed quite recently in 23 and has the position of an engineering and application manager. During 24, there are some collaboration issues with the team. They did some coaching and also included 3 Scrum Masters, and there was some support of the employee. And in 24, there was a performance review of the employee's communication style, and that remained dominant, and the employer offered coaching. Then the employee reported sick. Then there was a mediation, and that ended unfortunately after 1 session. And then he was informed that he could not return to his original team to a irreparable escalation. And then he was redirected to reintegration in another team. And there was also official warning linked to his communication style. At some point in time, he said, okay, I'm fully fit for work. And his first meeting took place to discuss the issues. Then the employer suspended him and initiated termination proceeding based on poor performance. The court rejected the poor performance since the employee received a very good evaluation in 23 and the employer never fully addressed the concerns through an official improvement process. Okay, there was some coaching, Scrum Master and management intervention, but there was not a PIP with goals, timeline and expectations. And the court ruled also that the employment relationship had gone seriously and irreparably damaged, with both parties stuck in a prolonged deadlock, including the mediation. So there was termination on the ground of disturbed employment relationship without awarding the employee additional fair compensation. So now you can see how it shifts. Real quick, some practical tips and best practices, because we're running out of time, I see. Make sure that you have an annual performance plan for every employee with clear objectives, including behavioral expectations. So next to the job description, an employee know what to do. And after a negative interim evaluation, start a formal performance improvement plan. Also try to avoid mixed signals. So don't pay a bonus or announce a promotion if somebody has some performance shortcomings. Clearly communicate that failure to improve may result in dismissal. The possible outcomes of a PIP, that should be clear. You should keep the redeployment options open throughout the process. And if there's no realistic expectation of improvement, then you can carefully offering a settlement agreement, but still have this other option open. If the process leads to a disturbed employment relationship, explicitly identify and document this, and also in some situations consider mediation. And where an employee fails to perform a task that he or she is no longer capable of performing, it may constitute refusal to follow reasonable instructions, and that could qualify a refusal to work, and then you can follow up with a formal warning. And if we look at the case law, there was some formal warning, but that was not in the right qualification and in the right order. And if the employee reports sick during the process, inform the company doctor and consider whether mediation may assist in resolving this situation. I rushed a little bit, I think, but you can later on read it through the slides after on. And then we start with some more recent case law.
Yes, thank you, Nikki. What we wanted to discuss about some recent case law and some topics is secret recordings, access to investigation reports, and employer liability for RSI damages, I think, or health issues. So with respect to secret recordings, we get a lot of times the question, is it allowed if an employee uses or records our conversation without informing me and use this secret recording in a court case against us or as me as an employer? This was also the matter for the Court of Appeal. In this case, initial court process, the employee started to claim damages, a fair compensation of 110,000 euros because the employer acted seriously culpable because the employer did not extended the fixed term contract, because the fixed term contract was in place for 12 months and it included in a side letter subject to satisfactory performance and good prospects for the organization, the contract will be continued into a permanent contract, which was not the case. So in September 2024, the employee's performance was reviewed by the employer together with the employee, and the employee secretly recorded that conversation. That discussion was about also the possible extension, and the employer made it clear that there was no final decision on the extension or an indefinite term contract. There were comments made on his performance, but also the employer said that he was initially positive to a possible extension. So there were some mixed signals, you could say, but eventually the decision was made by the employer. In October and November, additional meetings took place in which it was explained to the employee that his fixed term contract was not extended. So then the employee goes to the Court of Appeal to again claim this fair compensation. And then the Court of Appeal takes into account the secretly recorded conversation and the transcripts of these conversations. But the Court of Appeal also notes that because of the possible inequality between the parties, the employer and the employee, because the employer was not aware of those secret recordings, the court regards takes these transcripts into account with some caution, because you can imagine if you are not aware that you are recorded and the employee is aware that he is recording or she is recording the conversation, the employee can steer the conversation in a certain way. So the court will take it into account with some caution, but it is allowed to use those secret recordings during court cases. In this specific case, eventually the employee was not helping himself with these recordings, because following these recordings, the court came to the conclusion that there was no final decision yet, despite this discrepancies and mixed signals by the employer. But the court eventually, based on these transcripts, came to the conclusion that there was no final decision yet, and that it should have been made, it should have been clear for the employee. Another question that we get quite sometimes is that if an investigation report is provided, or as an employer you engage an investigation company to investigate certain aspects, do we need to provide that full report to the employee? This was a case between RET, which is a public transport provider in Rotterdam mainly, and an employee who was working there already since 1985 as section chief security. So in the beginning of 2024, several colleagues sent an email to the employer about a negative experience about the behavior of the employee. So following these emails, first the employee was suspended by the employer. Detail in this case is that the employee also started a summary proceeding to be allowed to get back to his work. That was rejected, and eventually an investigation took place about the work culture and the safety within the safety department. So the investigation included 21 conversations with colleagues and also the specific employee. So the conclusions for the employer following the investigation was that were negative, and eventually the conclusion was also, or you need to proceed with the process that you initiated with these managers, or you need to get back to the old process within the company, and then with a different leadership style, but then you need to take also actions. So the company took the action and the conclusion that they wanted to terminate the employment contract of the employee. Following those conversations, the employee immediately requested several times, actually, the full research report. Then the employer requested the district court to terminate the employment contract based on culpable conduct and a disruptive relationship. And to substantiate that legal ground for termination, the employer selected and anonymized parts of the conclusions of this report in the petition, and based on that substantiation, following that report, eventually the district court came to the conclusion to terminate the employment contract. And so the employee appeals against that decision. And the first request that the employee did was to have access to the investigation report. And then the first question that needed to be answered was, does the employee have sufficient interest to be granted access to the investigation report? And then I think that the employee made two smart arguments, is that the content of the report may be relevant to substantiate his defense and to prevent hopeless defense arguments for his defense. And the employer also, and also the district court, mainly based their decision on the investigation of the report. So those were the arguments from the employee. And he did that before he submitted his full defenses. So that was brought forward.
being mindful of the time, maybe we can just wrap it up in a few minutes. And
I will get to this very quickly. The other part is that the employer's arguments, the main arguments from the employer was that if we send the full reports to this employee, then it will have an impact on the employees who were included in the investigations. They do not want to work on a new report if necessary, and also their privacy. Then the court comes to the conclusion that those arguments are not strong enough to uphold the report for the employee. Also because the employee in this case gets the employer can anonymize the report, and the employee is held to a confidentiality that he cannot use the report outside of this court case. So the conclusion is that the employees are entitled to an investigation report, and that it's actually very difficult for an employer to refuse this. So I think, and the privacy aspects cannot justify without a further specific substantiation that sharing this report can be withheld. And I think also that this is an important decision from the Court of Appeal because employees have a strong argument now to receiving the full report. Then you have one final one, and I think that the questions that we got, we will answer them personally, so we don't hold any longer.
Yeah, I think what I want to add on this one, there is a Supreme Court case quite recently. It's not something you should be scared of, but in this court case, there was an employer liability for RSI. What I want you to remember from this case and the key takeaways, it's not a breakthrough judgment. In this case, there was a liability because of specific facts. At the flip side, you still need to be very practical here. And RSI remains a significant occupational health risk. And please maintain clear documentation of a risk assessment, ergonomic evaluations, follow up on health complaints, because in this specific case, there was an employer liability for an occupational health disease. I think we have to wrap it up. And if you have any questions about this, you can address it to them.
Submit it to us. Yeah. And one final question from us, please. If you have some time and left, fill in the webinar evaluation if possible.
Yeah.
Thank you very much
for listening.
And see you next time.